Hello, I'm attorney Vince Davis. Today we're discussing the massive shifts in California trust and litigation law occurring right now. From landmark Supreme Court decisions to new legislative mandates, the legal landscape for trusts has rarely seen this much change at once. The most critical development for trust litigators in 2024 was the resolution of the amendment paradox in Haggerty versus Thornton. For years, courts were split on whether you had to follow a trust-specific amendment rules or if the general state statute was enough. The Supreme Court ruled that the statutory method is always available unless the trust instrument explicitly states its own method is the exclusive means. Crucially, this ruling is retroactive. Many amendments once thought to be procedurally deficient are now legally valid. This completely shifts the strategy for many ongoing trust contests. If you're involved in such a case, a review of these procedures is vital. Moving to the legislature, several new bills are significantly altering how we administer trusts and handle probate. Assembly Bill 2016, effective April 2025, is perhaps the most impactful for California families dealing with real estate. It allows for the simplified transfer of a primary residence valued up to $750,000, bypassing formal probate. By using a petition to determine succession, families can save significant time and thousands of dollars in statutory probate fees. Combined with the current $184,000 limit for personal property, many estates under $1 million may now avoid probate entirely. Next is AB 565, which introduces virtual representation to California, aligning us more closely with the Uniform Trust Code. This allows one beneficiary to represent another similarly situated beneficiary, such as a minor or unborn heir, regarding notice. This is a major procedural win, as it reduces the frequent need for court-appointed guardians ad litem, speeding up the legal process. We also have the new Directed Trust Act, which clarifies the roles of trust directors, third parties who hold specific powers like investment authority. Let's talk about trustee duties. We've seen a 35% increase in trust contests in California recently, making liability a major concern. The core duties remain loyalty, impartiality, and transparency. Failure to account or inform beneficiaries is the leading cause of litigation. The penalties for bad faith are severe. Under Probate Code Section 859, a trustee can be liable for double damages for taking trust property. Recent case law clarifies that these double damages are in addition to the return of the property. This is a massive deterrent for fiduciary misconduct. Trustees must also now account for digital legacies, including cryptocurrency and social media, under the revised Fiduciary Access Acts. If your estate plan doesn't explicitly grant permission for digital access, your trustee may be legally locked out of these valuable assets. A prominent trend we're seeing is the merging of trust contests with financial elder abuse claims. Undue influence now accounts for nearly 42% of all trust contests. Litigators are increasingly using elder abuse statutes for their superior remedies. Unlike a standard trust contest, financial elder abuse claims allow for the recovery of attorneys' fees and costs, which is a game changer for plaintiffs. The 2025 Heron decision established that elder abuse restraining orders can be issued even without a prior adjudication of mental capacity. A critical warning for beneficiaries. Once you receive a notice of trust administration, you generally have only 120 days to file a contest. If you miss this window, you may lose your right to challenge the trust forever, regardless of how much evidence you have of undue influence. California has also introduced much stricter oversight for the conservatorship system in response to recent public scrutiny. Under Senate Bill 280, conservators must now file a detailed confidential care plan within 120 days of their appointment. Failure to file this plan can result in a $500 penalty or even removal from the position. It's about dignity and accountability. By utilizing these new streamlined procedures, families can reduce legal costs by an estimated 60% compared to a traditional formal probate. Importantly, roughly 65% of contested trust cases in California now result in a settlement or modification rather than a full trial. Navigating these settlements requires a deep understanding of the evolving probate code and recent Supreme Court precedents. With nearly 40 years of experience in California courts, I've seen how these changes impact real families and their inheritances. Protecting your legacy means staying ahead of the law. Whether you are a trustee or a beneficiary, you need to know your rights today. As we move deeper into 2025, ensuring your trust documents are updated to reflect these new rules is non-negotiable. If your trust hasn't been reviewed in the last 2 years, it is likely out of sync with current California law. We specialize in California-specific regulations, focusing on the intricate details of the probate code that others might miss. Our goal is to provide you with the peace of mind that your estate is handled with the highest level of professional care. Thank you for watching this update on California trust and litigation law. Staying informed is your first line of defense. We are here to help you navigate these complex changes and protect what matters most to you and your family. Call us at 888-888-6582